with the big story, day one of the hearings at the Supreme Court, those petitions challenging the re-election of President Uhuru Kenyatta. I'm here with Joy Brenda Mdivo and Kakai Kissinger as we do our analysis. Kakai, I'd like to start with you first. Before we get into the nature of these petitions and how they differ from those after the August 8th election, interesting happenings in court with the AG being admitted as an interested party as opposed to amicus curiae. What are your thoughts on this?
Thank you very much. One of the things that is always a nightmare is the time frames that are given by the Constitution that the Supreme Court must comply with. And you know they have 14 days to do so. But even when you count the number of days that they are allowed, actually they have only less than 7 days for the Supreme Court to actually hear all the parties and make a judgment out of it. So they are always squeezed out of time. And so the reason why they limit the number of participants in the electoral process or in the electoral dispute is to try as much as possible to manage the time frames. So in the circumstance, therefore, then it's prudent that the Attorney General is given very specific timelines and also very specific roles. So limiting him from being an amicus and making him an interested party to the court or to the mind of the judges is to save on time, in the sense that the Attorney General can submit whatever he wants to submit as an interested party as opposed to amicus curiae. If he comes in as an amicus curiae, then he's submitting on matters or points of law that are so critical to the case. But now that he has come in as a friend of the or as an interested party, then he will be limited to make his submissions towards a certain point of law or towards a certain political divide. So that's the most interesting thing, but it's just because of the fact that there's always limited time frame for election hearing and petition judgment in the petitions. Okay,
Joy, just a quick one to conclude on this one. I suppose because of precedents that we have seen with this before, do you see any issue with the government's chief legal advisor now being an interested party and in essence making an argument for a particular side as opposed to being a friend of the court and being a neutral party in the proceedings?
Being an interested party is not such a bad thing, actually, because what he is able to do, as you have correctly pointed out, is the chief legal advisor for the government. And where the government has been adversely mentioned, maybe the police force has been adversely mentioned, he is able to lead particular evidence or specific evidence towards those matters that would be of interest to the government to defend, that the IEBC lawyers or the lawyers for Honorable Uhuru may not be able to canvass. So it is something that also helps to move the process forward. Remember, we had the LSK as well as the AG being amicus curiae the last time. And the areas of law that they canvassed have already been settled. And if the judges need to refer to that, the Hansard is always there and they can go back over it. So there is no need for him to rehash the role that he played last time. It would only make sense for him to play a role that is not only new and unique, but useful in this particular set of circumstances. So it is something that is not such a disaster. And also seeing how the judges are very firmly in control of this process, we do not expect that the Attorney General then would sort of run away with the show. He would be able to keep it structured within the confines that he has been asked to submit towards. So, for example, if you're responding to a particular incident, just give us what is referenced, and after that, just leave the rest to us. Okay. So it's a good thing. It's not a bad thing, in my opinion.
All right. Okay. So I suppose we will see his presentations before the court tomorrow, and that will be interesting to follow for all that are following these events at the Supreme Court keenly. So let's talk about the nature of this petition, Kakai. I mean, you know, the last one was all about the process of the election. The petitioners weren't necessarily going for the numbers, but just saying, remember, it was all about the formula. How did you get to the final outcome? Is that the same case with these petitions before the court?
Thanks, Yvonne. The current petition is completely unique and different from the previous petition. When you look at the previous petition, we had two questions that the courts were dealing with: the qualitative analysis of the petition and the quantitative analysis of the petition. But now this petition is more of the qualitative test that is being subjected. What do I mean by qualitative test that is being subjected? We are not seeing so much hype or cry about documentation. It is there, but it's very limited. We are not seeing so much claim on irregularities. They are there, but they are very minute. What we are now seeing and observing more in these petitions, and with those petitions that are before the court, is the issue of qualitative test. Was there a free environment to carry out the election? Was there devoid of violence in terms of the electoral process? Was there a free and fair election? Was the environment good to provide an atmosphere to carry out a free and fair election? Was there intimidation? Or if there was intimidation, what happened to it? So we are seeing that more of the petition is around the IEBC and how the IEBC were able to conduct the election, whether it was free, whether it was not free, where there was devoid in terms of violence and so forth and so on. So the test that is being subjected before the Supreme Court in this petition is of a qualitative test or a qualitative nature.
All right, and in the event of a qualitative nature, Joy, what would be the standard of proof or the threshold of evidence for the petitioners to prove to the judges to make a case?
Let me add something to what Kekai said first, and then I answer your question.
Okay.
When you look at the situation as well, the last 60 days have been awash with different interpretations of the law. You've looked at references to the 2013 decision. Paragraph 290 became very famous. Article 138, Article 136, Article 140. And we realized that the law was very clear and not very clear at all. And I'm glad that now we are canvassing more on the issues of the law. And hopefully, jurisprudentially, we should be able to build a basis upon which either we can have future reforms of the law or clearer interpretation of what the position would be. For example, what's the import of declaring a fresh election? When does it start? So these are questions of law that we're looking forward to them being settled fairly once and for all. And now coming to your question, when you have a situation where you're looking at the standard of proof, it is in between things. It is not to the level of beyond reasonable doubt, but it's not as low as on a balance of probability. So there's a fairly high standard that you have to prove. That's why you had issues being talked about, like going on a fishing expedition, or people are not really sure what they're asking for. And the judge is also being very particular, saying, you asked for very specific things. Can you please prove those things that you asked for so that we can be able to determine what sort of orders to give you? And that is a very tricky road to follow, because the law tells us he who alleges must prove. So if you're coming to court and you're putting in a prayer in your petition, you better have something to back it up. And so the standard of proof is slightly above on a balance of probabilities, but is a little bit lower than beyond reasonable doubt. So that's basically where we are right now.
Yeah, I suppose a lot will center around what happened in those 60 days, what happened from the 1st of September, when the Supreme Court annulled the re-election of Uhuru Kenyatta in that August 8th poll. And, you know, by the time they were then conducting the election, they had set a date, they postponed that. All of these are issues that will be discussed before the court. But, I mean, the environment in which IEBC was trying to conduct an election will be important, right, Kaikai?
Yes, and I think, you see, the judges in this, who are sitting there in this petition, are also part of electorates. They also participated in voting. And they are aware about these things that happened around there. And remember that they are part of the society. So when they are going to make a decision of whether to annul or to dismiss the petition, the key thing that will carry the day is the environment. The question will be then what happened after we annulled this election, what we gave specific orders or specific conditions to be met, were these conditions met or they were not met? Number two, what were the security agents? Because an election process involves the IEBC itself and also security agents who actually man these election agents. So there will be evidence, and you've already started seeing evidence coming in, to the fact that IEBC was completely willing to comply by the set conditions, set standards that were made by the court, but then the conditions were completely beyond their way of achieving these objectives. So for me, the judges will be looking entirely on what happened before the election, during the election, and even after the election that it has happened, what is really the environment around it. So there will be questions towards, really, do we have to annul this election again? Is it that the IEBC did not do what they were supposed to do? Or is it that there are some other actors or players in the electoral process that completely made it difficult for IEBC to achieve what they want to achieve. If I do recall very well, the IEBC chairman, Wafula Chebukati, came out very clearly and answered all those concerns that were there in terms of him delivering or making sure that the electoral process is free and fair. And if he's able to bring that evidence tomorrow, which of course we will all expect, then he will be answering most of the questions that, according to him, he was able to deliver election free and fair. According to him, he did everything that he could do to ensure that the country goes through an electoral process. According to him, he wanted to deliver the election to every registered voter in the country. And he will be able to say why he was not able to deliver election in some parts of the country, and he should have a justifiable reason why he has to do that. So the court will be analyzing the basis of that vis-a-vis exactly whether the election was free and fair and whether the IEBC had done all it could do to ensure that the electoral process is free and fair.
Okay, just to buttress your points there, I want us to listen to the chair of the Independent Electoral Boundaries Commission, Wafula Chebukati. And I'd like us to listen to two of his statements made at different points in time. One where he was decrying that environment that Kakai is speaking of, both internally and externally. And of course, when he did feel that he was now in a position to conduct a free and fair process. Listen.
I've made several attempts to make critical changes, but all my motions have been defeated by a majority of the commissioners. Under such conditions, it's difficult to guarantee free, fair, and credible elections. Without critical changes in key secretariat staff, free, fair, and credible elections will surely be compromised. I cannot continue to be pushed by majority commissioners to accept legal opinions that serve partisan interests and are not grounded in the Constitution and the law. In the least, I find this as intellectual dishonesty for which my professional training demands that I abhor. I would rather bow out with my name intact and my head lifted high than be part of a process where personal interests drive the interests of the nation.
All right, so those were the statements by Wafula Chebukati, and of course talking about the internal environment and the external environment with the IEBC. We of course know that those internal memos that were leaked will not be admissible in court, but perhaps these statements might be considering as they were made in the public domain in the media. But I'd like us to speak about an issue regarding the boycott of election or the election not happening in all 290 constituencies, the issue of universal suffrage. Joy, we all know that in a repeat election, whichever it is, including a by-election, the turnout is always much lower. Would this be a factor that the judges would consider?
It's a very interesting question you pose, because we just came out of the Kitutu Chache by-election. And I think turnout there was also something in the 30s, it was like 38, 39. And so it's true, people get to a place where they're tired of this. And it is a voluntary process. It is a time-consuming procedure. And it is something that also for, now, like the people in Kitutu Chache, that was their third election in a very short span of time. So you can understand why the voter enthusiasm was not as robust as we saw in August. But be that as it may, there is a question that you said of the turnout. So is it really a suppressed turnout? Because we know that there was an active boycott. So of the people who are not participating in the boycott, then can we suppose then that the turnout was robust if you're looking at the people who actually turned out to vote? Because if you know why people have not turned out, it's not a surprise when the numbers are suppressed.
Because, you know, the question that you raise about, you know, voter suppression, how would you be able to prove something like that in a court of law, that, fine, there was a boycott, but I didn't feel that the environment was safe, without perhaps hearing from a voter that says it? I mean, would such proof be required before the judges?
It would be useful, and that's part of the problem with the matter being canvassed at the Supreme Court. Because at the Supreme Court, you cannot call Joy on the stand and ask her to tell you what she felt in her area. For example, you know that there are people who, when they went in to vote and came out from voting, they were beaten. And so the people at home, when they heard, oh, you got beaten and you went to vote, they decided to stay home. You can't call them to come to the stand. So unless you have an affidavit already put as part of your pleadings, you may not be able to lead evidence in that direction. And it's one of those things that becomes also difficult to understand. Now, if you're saying that turnout was X%,
yeah.
Now, it is X% of who? Who exactly are we counting in this percentage? If we look at it, there it is textbook, you're counting of the registered voters. So you'll say that it was 30% of the registered voters. But we know that there was an active portion that decided to not participate. So if we look at the ones who did participate, what was the real turnout, quote unquote? And it's very difficult because when you look at when the results were being announced, it was 98% of what? Of the cast, the votes that have been cast. Does that count the ones who did not participate? Which was a vote. It was withholding a vote was actually, in a way, voting.
Right.
But it does not count in the numbers at the end. So the game of numbers, in my opinion, does not really matter. Because if you look at our laws, it doesn't say turnout must be at least 20% for the election to be valid. Right. It just says of the votes cast. Right. So even if only 100 votes were cast, does it meet the threshold? The 50% plus one, the 25% in at least 24 counties? If it meets that threshold, then you're good to go. And unfortunately, that's how the law goes. That's how it is set up.
And it's interesting about that because I don't know if we would want the judges to be as prescriptive as that, in the future and say, the turnout should be this for this election to be considered to have been legitimate. But then there's the question of the 50% plus one, which we put in our constitution, 25% in at least half of the counties. That's going to be an interesting proposition for us to consider going forward, even beyond this Supreme Court hearing, because certainly, Kakai, voting is not mandatory in this country.
Let me make it also very clear in terms of add what my colleague Joy has talked about. When you look at the constitution of this country and when you look at the referendum Act, the Constitution allows, of course, universal suffrage and people going to participate in terms of voting. But the same Constitution doesn't say that it's mandatory to participate in the electoral process. Then, number two, when you look at countries around the world, this is given in terms of people must go and participate in the vote. And then if they participate in the vote, then it's their right. But you cannot force them to go and vote or participate in the vote. Now, the courts would not be looking per se at the issue of voter turnout. It's completely irrelevant here because we apply a system called first past the post. First past the post is a system that is applied in electoral system that is applied all over the world, and it's actually the second popular voting system all over the world. What first past the post simply means is that the majority or the person who gets more votes then becomes a winner. So when the court is looking at these things, the issue of voter turnout as a debate in terms of, there were a few people who came up to vote or to participate in the vote is completely irrelevant. The question will be, was IEBC in a position to administer an electoral process? And if the answer is yes, did they administer it? Were they able to give all the people an opportunity to participate in the vote? Yes, if they did. And if they did not do that, what were the conditions that made them not participate, people not vote? But then the issue then comes in, when you look at around the world, even in a referendum, there is no specific requirement of the number of people who should participate or to participate in the vote for a referendum to pass. It's only South Sudan that did that, and they put it at 60% because of the question that was happening. Look at the other day when we went, the British were going through the referendum. There was no markup or requirement in law that required them to participate in terms of passing a motion. So the question of numbers is completely irrelevant in terms of the court coming up to a decision with that. What the court will come up with the decision is whether the process was due and whether the process was fair.
All right. We have about 5 minutes to go, so I want to pose this question to both of you. I asked this to the advocates that I hosted last night, and this is about the decisions that are being made. Will there be a possibility that public interest will feature in this case as opposed to just the evidence that is before the judges? Joy?
All legal proceedings hitherto have had public interest at the central pillar of everything. Because even you look at the annulling of the election, the big idea was to ensure that the will of the people is heard, was to ensure that the processes that the people, through their representatives, have passed as law is strictly adhered to. That what the people passed as a constitution is something that is the rule that IEBC uses in playing this game or in adjudicating this game. So public interest has been central of all these processes and will continue to be central in all these processes. Now, if you're asking in terms of public interest in the sense that will they decide to look the other way at evidence because they want to preserve certain status quo, that is a question that would be unfair to answer at this point. Why am I saying that? It is because it is presupposing that the judges have already made up their minds and they're simply exercising, going through this exercise to sort of window dress. And I refuse to think that our judges would stoop to that level. I would imagine, even if they get to a position where, for example, let me give an example of Judge Odunga. When he was hearing the matter about the gazetting of the returning officers,
yes.
He also made an allusion to that public interest.
Yes,
and
he did.
His argument was very simple. He said, look, should they have told the political parties about it prior to? Probably they should have. Yeah. But in this particular instance, there are 40 million Kenyans who are waiting for this outcome. I think these ones who are not told about the returning officers can sort of wear the big boy pants on behalf of the 40 million who are waiting for this tomorrow. So in such a situation, the law was stated clearly, the position was stated clearly, and the judge made the decision based on where does the balance of convenience fall, with the Kenyans or with the petitioners?
Yeah, so ruling that it was done irregularly and unprocedurally, but not exactly annulling the whole process and starting from scratch.
Yes.
Okay, interesting. Kakai, your final thoughts?
My final thoughts is that I've said before, and I will repeat, it's not always an easy task to annul a presidential election. I said before that time, I think, in my opinion, the courts were completely wrong to have annulled the presidential petition at the time. The best they would have done was to reorder for a recount of the votes, but then they did it, and we are stuck with that decision. It is still, in my view, remains a bad law at the moment. But this time around, it's going to be very interesting because this court, when they were making that decision, they did not know that there will be somebody who will wake up in the morning and say, we're going to have a boycott, and they will refuse to participate in the electoral process. So then the court must now think outside the box and apply what we call extrajudicial means to try and put the voter in the right place. And the only time the court will do that is this time round. Because what makes you think that when they annul the election this time round, the other parties will want to go into the electoral process? So the courts now must think beyond what they did that time and say, look, let it be the will of the people. Let's give the people what they chose, and we are not going to take it away from the people because this is what they wanted. So in my view, yes, they will think outside the box, and they will make a decision considering the opinion or public opinion of the people.
Kakai Kissinger and Joy Brenda Madivo, I thank you very much for your time on The Big Story this evening. Day 2, of course, resumes tomorrow at 9 a.m. and we will be here once again on The Big Story to give you analysis of this case as it proceeds with these 2 petitions now before the Supreme Court. Remember, D-Day is Monday, midnight, the 20th of November. Thanks very much for watching The Big Story tonight. Please do stay with us to continue to get the whole story here. I'm Yvonne Okwara Matole. Have a good night. Yusuf Ibrahim is next on KTN Prime.